Welcome back to the Michigan Business Beat, brought to you on the Michigan Business Network. Chris Holman here, coming to you from our studios at the Capital Region International Airport. We're going to stay in the area for right now. Cliff Hammond, he's a shareholder, employment and labor lawyer with Foster Swift Collins and Smith, offices in Southfield, Lansing, and who knows where else. The last I knew, they were pretty much controlling the whole state of Michigan. Cliff, welcome back. It's good to have you here, buddy.
Hi, Chris. Great to be here. Thanks.
Mid-March already, 2025. The ESTA seems to be changing about every 36 minutes. Where are we at as of right now?
Well, the good news is we haven't had any new law that's been changed, but we have a lot of interpretations that are needing to be made. And so what we're seeing is some guidance being put out by the state. We've got our posting updated, and I anticipate we'll have some more FAQs coming out from the state of Michigan to help us a little bit more. But the good news is I don't think there's any pending deadlines to get this thing changed again.
All right, so the governor just signed this compromise. Tell me about some of the key points of that.
Right, it was a pretty good compromise. Unfortunately, it came at midnight, so everybody was waking up to know what they had to do the next morning immediately. But there's some good things in here for everybody. First of all, the number one thing is it took out the right of a private suit. So employees can't run down to the courthouse, get their favorite attorney to file a lawsuit on their behalf and everybody else, as well as all these damages that were out there. So we took a lot of the things like attorney's fees. Well, that's not going to necessarily be there anymore. At least it's not in statute. That's good news. Liquidated damages, which meant some extra damages in case you did things. So those are gone. That's a great part of the compromise. In fact, who knows? We could have had class action lawsuits. This thing could have been shut your business down, not because you did anything really that bad, but because of the costs and the weight of defending it. So that's the number one compromise. Other things that came in here, some common sense approaches. Hey, let's let people front load time to 72 hours, not carry a giant bank of time over. And we were able to get some common sense approaches to what's a small employer, how do small employers front load, how do they accrue, and gives a little bit of time for small employers to come into compliance.
So tell me, who has to comply at this point?
Pretty much everybody's going to have to work. If you work, if you have a business and you have one employee or more, you're in. The only real exception is for our federal employees. And so if any of those are left, we're going to continue to have those non-federal employees that are going to comply. There's a couple employees themselves inside of companies that aren't going to be counted anymore. We got some clarifications on that. So most of your elected officials, your government workers, people who are under Youth Standards Act, your young workers, some people who schedule their own schedules but don't get anything adversely taken against them if they don't work so many hours. Those types of people aren't going to work. But for the most part, if you're an unpaid intern, you're not going to get time off because you don't really get paid in the first place. But everybody else is going to be either a large or small employer with requirements.
All right, so is there different deadlines for different sizes?
Yeah, so for most people, if you've got over 10 employees, you're already in the bonus. You should be doing this. You already are supposed to be accruing time. Your time has already started. You're on the clock. Now, you've got a little bit of time to put the posting up that the state had to get together because, again, they passed the bill and then had to get it signed. And they were doing things on the 21st when it went into place. So you got a little bit of time until the end of this month, the 23rd of March, to get that posting up. But you're supposed to be accruing time, getting your policy out to employees, putting it retroactive. But if you're a small employer with 10 or less, you've got a couple different ways you can look at it. If you didn't have employees before February 21st of 22, then you have 3 years from the time you hired your first employee to get going and get accruing and be under this law. So a little bit of time for the small employers that were hired then. If you're a small employer who's working now and you've had employees for a while, you've got a little bit of time to start actually accruing their time, the employees' time, and that's until October. So you're supposed to put the posting up, you're supposed to start, drafting your policies, but you've got a little bit of time. So you got a three-tiered process of what's going on, but basically, are you a large or small employer, and were you new or are you existing? So that's where really it's at.
So is there anticipation of any other changes at this point?
Well, we don't know that there's anything on the block right now, but you know what? Budget season's coming up. There's lots of things that could happen then. We could start clarifying some things in the statute itself that came up that maybe we didn't anticipate. And who knows, right? There's always a horse trade to be made, but nothing on the horizon right now.
How about blind spots? Anything employers should know about in that regard?
Well, there's lots of blind spots, but the number one blind spot is people trying to be too cute. And one of the things that I see is people trying to be overcomplicated to not give the time they're supposed to give. And I say, well, wait a minute. We don't know a lot yet. Stay on the side of being conservative. Don't get too cute. For instance, what you don't want to do is try to fit yourself or squeeze yourself into saying, well, all my employees really decide when they want to come to work. And it's more complicated than that. So you want to make sure you're on the right side of not giving people the wrong amount or carrying over time and getting yourself into a potential where the state can come after you.
We got about 15 seconds left. So is there a format anywhere as to how this is supposed to be presented if someone gets audited on it?
Well, there isn't necessarily a format yet. I'm sure it'll come out, but the long story short is everybody should look at how they do their business, see how they do their records, make sure your record keeping is done. Talk to your attorney, look at your internal resources and make sure you have that in case you do get audited or you do have a claim, because the state can come after you and actually take a case to court against you. So we want to have something that fits your business and your model.
Something substantial. Cliff Hammond, shareholder, employment lawyer with Foster Swift, Collins and Smith. Thanks for clarification today. We'll call you again tomorrow.
Sounds good. Thanks.
Hey, thanks for being with us. You're watching the Michigan Business Beat on the Michigan Business Network. I'm Chris Holman.